it's sort of a little known right that originates in the British common law. So to back way up, Marianne, way before there were such things as police or public prosecutions, if I stole your wheelbarrow in the UK in, say, the 1600s, you would bring me to court. There was no agency that you could go to and say, this person stole my wheelbarrow. Please bring a charge and get the wheelbarrow back. It was a responsibility that people had on themselves to privately prosecute someone. And so that's how the criminal law sort of originated. And over time, of course, we developed police agencies and public law enforcement authorities. But the right to privately prosecute remains, and it's quite robust in the UK. We imported that from Canada because, of course, we were a British colony at one point. And the right remains in our criminal code, although, as you pointed out, it's been attenuated over the years. So technically, I can bring a charge if I believe on reasonable and probable grounds that somebody has broken the law. I don't need to be a direct witness to those events. I just need to have information and be able to show that I have a reasonable belief that it occurred. Now, what the downside is, of course, and especially when it comes to animal prosecutions, is that the crown attorney, which is how we refer to prosecutors in Canada, they still have the right to intervene in that proceeding and to oversee it. And that exists so that you don't have people just, going ahead with private grudges against their neighbors or against other folks that they don't like. I think there's some good policy reasons for, public oversight over these prosecutions. But, essentially the Crown can do one of three things. They can, they're entitled to know when someone has tried to file private charges. They can decide to just stay out of it, let the case proceed, and they might keep an eye on it or they might not. They can decide to take over the case themselves if they think it has merit. They can look at it and say, well, we think an offense has been committed and we're going to prosecute this. Or they can decide to stay the case. And that's what happens in the vast majority of cases is they look at it and they determine it's not in the public interest or there's no reasonable prospect of conviction. And so they intervene and they stop the proceeding.
Yeah,
so
by stay the case, you don't mean temporarily. You mean it's over, right?
It's done. That's right.
Yeah. So that we can now see can be a big problem in animal cases. But there are other problems as well. I mean, we should mention, in addition to this fact that the government basically has this kind of veto power, you mentioned that you had brought access to information. Is that the name of the statute?
That's right. The
Yeah.
FOI equivalent.
Yeah, so you can find out some evidence that way, but you don't have many of the powers of the prosecution to investigate and find out what really happened. So already you're in a much more difficult place than a governmental prosecutor, right?
Yeah, that's exactly right. And, especially when you think about the regulatory context, regulatory offenses are often heavily document based. There are documents that are kept within the possession of a regulator or an accused person. They're not documents that are usually in our possession. And we were able to get many documents through access to information requests, but there are often redactions. And access to interview witnesses as well is something that we didn't really have.
Yeah.
So,
Yeah.
We'll get into that in a little bit, but we definitely are at a disadvantage compared to an enforcement agency that wants to bring a prosecution.
Yeah, I mean, it's important to remember that. Nevertheless, here we are. So what's the first step for a private party who wants to be allowed to bring charges that they think are real, but the government is not doing anything?
Yeah, so the first step is you swear in information. So in this case, I was actually the private informant, and we went to the Winnipeg courthouse. We swore, essentially we attempted to lay 3 charges initially. So there were 2 federal charges under the Health of Animals regulations. The first, those 2 included violating the 28-hour law and failing to have a contingency plan. We also tried to lay 1 provincial charge under Manitoba's Provincial Animal Welfare Act. And that charge was essentially for causing distress to animals, which we believed had occurred based on the, going over the time limit. And we know that actually at least 3 horses collapsed on this flight as well. So we go to the courthouse, we swear that information, and then the next step is scheduling what's called a pre-enquête hearing in front of a judge or a justice of the peace. So that involved, it's a bit of an unusual process. I won't say
Yeah.
private charges are common in Canada. So there was a little bit of confusion among court staff and judicial officials and figuring out what room we needed to be in, when the hearing was, what
What
day of the
room you
week that
need to
was
be
on.
in is the hardest thing about being a lawyer, I swear.
I know, especially if you're in a courthouse that you're not familiar with and you're trying to sort through the ins and outs. It's a big deal.
Yeah.
So
No, that stuff is so much more difficult than it gets credit for. Yeah. So I
yeah,
appreciate it. At least you were dealing with other people. Well, if I can go one way or the other, when the people in charge don't know what's happening either they can be cooperative and understand that, or they can just get very difficult and want to pretend that they really know.
yeah. I'll say the nice thing about doing this case in Winnipeg is that Manitoba is known as the friendliest province, and it's true. People there are lovely.
Manitoba is the Canada of Canada.
It's the most Canadian province.
All right, just to clarify, so you have provincial charges and state and federal charges. Just to clarify, who was the prosecutor that wasn't bringing charges? Do you have to notify the prosecutor who would be otherwise, and was it actually two separate parties?
Yeah, that's right. That's right. So the way Canada works actually is that federal charges are prosecuted by a federal prosecutor and provincial charges at that level. So we actually had to provide that information to both prosecutors, and then they both independently, and I guess they're allowed to speak as well, but they're allowed to determine what they want to do with those charges. And so after we swore that information and before we had our pre-enquête hearing, much of the situation was trying to figure out what those prosecutors wanted to do and if they were going to let us proceed on those charges. And it took some time for them to make that decision. Ultimately, the provincial crown attorney determined that we would not be allowed to proceed on that charge because their concern was the offense was probably committed, if there was an offense, somewhere in the air, not inside the jurisdiction of Manitoba. So, that's a bit of a tricky issue. That charge was not, we couldn't proceed on it.
And the other two charges, it was up to the federal prosecutor. And
That's right.
does that decision get made before the pre-enquête hearing or during the pre-enquête hearing or after?
It could be made at any time. Sometimes I was involved in one other private prosecution earlier in my career, and in that one, the prosecutor told me that he wanted to see what happened at the pre-enquête hearing and what the evidence actually
Okay,
was.
it's fair.
In this case, the evidence wasn't really contentious. It was documents.
Documents.
Everybody knew what had occurred. And so we were able to get a decision from that crown attorney beforehand. That crown attorney, the federal crown, chose to let us proceed on the contingency plan charge, which was great, but felt that for the other offense of exceeding the 28-hour time limit, that Carlisle Farms would have the defense of something called officially induced error. And so that's a defense where, essentially, as an accused person, you're saying, well, the government told me it was okay. And the reason that the Crown in this case thought that defense could apply is that when, recall Carlisle is loading the horses into the plane and gets this news about the delay, and they get on the phone to try to figure out what to do, the CFA was there. And the CFA
Mm-hmm.
was sort of part in some way of that decision. Like the CFI veterinarian, Dr. Max Pop, was there on the ground, was having conversations. And although it's not their role to approve or disapprove of a shipment in that way, he was kind of in on the decision. So the Crown Attorney thought that because the CFA had essentially consented to letting this shipment go, that Carlisle could have that defense in this case. I don't think I agree with that, but that was his decision.
So there are these rules, and the defendant knows about the rules, but somebody from the government at least implies it's okay if he breaks them. So then the defendant is off the hook. But the government doesn't get in trouble either. Is that how that works?
Well, see, that's why I don't think his defense applies. It's not that government can just give you the permission to break the rules. It's that there has to be like an honest mistake of what the rules are based on what a government official told you. So we just don't have evidence about what those conversations were. And I think if he put forward evidence that the CFIA had said, no, you're complying with the rules with this shipment, maybe we'd be in a different story. But there was no evidence called at trial, and we don't have evidence that there was ever any like official, approval of it on the basis that it was lawful. So yeah, I
Yeah.
mean, essentially what you said is right. He can break the rules and nobody gets held to account through this theory.
So, I mean, I assume I know the answer to this, but that decision of the prosecutor to stay one of the charges is not an appealable order, I take it.
Generally, no. Barring some evidence of what we would call abusive process, it's
Okay.
not possible.